So I would like to open the floor to questions from the audience, and I will not yet exercise my moderator's prerogative to ask the first question because you've been so patient. So please, please, I think it would be easier if we could line up and be sure to use the microphone, because we are taping this, we want to be able to be sure to get your questions heard. So. Oh, pardon me. If I could, please be sure to ask a question and not simply make a statement.
Hi, my name is Manuel Sanchez. I'm with United Bronx Parish. We're a human service agency in the Bronx, but we are planning on teaching a course called on the war on terror, civil liberties, and presidential power. My question is this: in the wake of the Padilla case, since that case was not heard, did that leave a precedent that other presidents would, essentially do what was done in his case, is essentially disappear a United States citizen, and hold them and never, in his case, languished for 3 years. And I'm not saying he was a good guy. I'm saying that, the citizenship stands for something, still in this country, and that by the United States Supreme Court not hearing the Padilla case, even though he had been moved to a civilian prison, does that pretty much set a precedent that, or at least leave it open that other presidents could come in behind in the future? They said, listen, it was done before, we could probably do it again. And I have one follow-up. The Office of Legal Counsel, which wrote the memos to give cover for Guantanamo, wiretapping, and so on and so forth, the black sites, and based on your experience, has that office become somewhat more reformed, or has the mindset in that office changed within your administration? Thank you.
I think if we'd like to address the second question first, that might be the perfect question for Mr. Engel.
Exactly. Well, from my point of view, and others may have other points of view on this, we were involved. I was at the Office of Legal Counsel from 2006 to 2009, and some of what we did, both internally, things that were actually subsequently released, but also in dealing with efforts on the Hill, was to address certain opinions that, when they were written, were done at a time of great stress, and were done at a time where there was a lot going on, and where, I guess, my personal view, the office didn't live up to its usual standards. But I hesitate, given it as a successor, to judge, in that respect. But so I don't think that the Office of Legal Counsel, in my biased view, had an issue in the last years of the Bush administration that needed to be changed. I certainly think that, just like with every administration, there are new folks there and they have new views, and some of their views will agree with the views of the office during the whole part of the administration and the latter parts of the administration, and some of their views will be different, and that's natural and normal. And so, with respect to OLC, I guess I'd offer that. The Padilla decision was vacated, the Fourth Circuit decision, by the Supreme Court. As a formal matter, it is no longer precedent, but you're clearly correct by the Supreme Court not reviewing the matter. The law remains unsettled in that respect, and it's certainly, the reasoning in the Fourth Circuit opinion may well be relied upon, or at least relied upon by other courts again. But I guess my view would be that the government had good justification for some of the positions that it took in those decisions, and it was upheld by the Fourth Circuit. Others may disagree, but that's an issue that may be tested, in future cases, if the situation arises.
Professor Eaton.
Just a clarification: the Padilla decision, the Fourth Circuit decision, was not vacated. The Almari decision involving the legal resident in the U.S. was vacated, but the Padilla decision was not. It's still precedent. I think it's not viewed as, to put it modestly, not viewed as a forceful precedent. It's viewed as a very tarnished precedent, given the circumstances that Padilla was charged and attempted to be moved out of the brig when the case was before the Supreme Court on a petition for certiorari. In fact, just two business days before the government's brief was due, and provoked a very strongly worded dissent from a conservative judge, Michael Ludig, who's since retired from the bench, basically accusing the administration of gamesmanship and of manipulating the judicial system. Now, as a formal matter, so its precedent, I think it's viewed, as I said, as a tarnished precedent, but more importantly, the question itself of, can a person, citizen or legal resident in the United States, arrested in the United States, be detained militarily without charge, has not been resolved. I would say one other thing about Padilla, though. Just last week, Padilla had filed a damages suit to recover for not just his detention, and I think that's a more problematic claim given that whether or not it was clearly established at the time that it was illegal, but for his treatment, which he's alleged involved very abusive techniques bordering on, in some cases amounting to torture. The case was thrown out by the district judge for various under various doctrines that make it difficult generally for prisoners, or have made it difficult in the past decades for prisoners to bring litigation challenging the treatment. But I think that case is not over, and there'll be a very different response in the Fourth Circuit. And the message in my mind of that case, as the counsel for Padilla put it, is that you walk away and Donald Rumsfeld is above the law, Jose Padilla is not, and is beneath it, and that's not very American.
Sam?
Actually, before, can I just add a footnote? Not to unduly expand this, but to respect your question about what it means where the individual under the spotlight, let's say, is a U.S. citizen. There's a whole other issue about targeted killings involving Mr. Al-Awlaki, who is a U.S. citizen. Right? So, that's different panel. But, the concerns about what it means to be a U.S. citizen when the government proposes to take grave adverse action is unresolved. There was a standing problem in the effort to get the district court involved in the Al-Awlaki case.
This may also be for another panel, but building off what Professor Hayford said about it's not so much Guantanamo, I think that's what he meant, as the policies and what's going on, and I believe that the ambassador made reference to Bagram and so on. What about those detainees, and what about our policies with respect to detention facilities, other detention facilities outside this country?
It's a great question. Thank you.
Well, yeah, excellent question. And at Bagram, where the U.S. is continuing to detain individuals, right now the current law is those individuals don't have access to a U.S. court. The D.C. Circuit overturned a district judge decision giving at least some of the Bagram detainees, specifically those who were brought to Bagram from elsewhere, which is not the majority, but still a not insignificant number, access to habeas corpus. The idea being, the Supreme Court's decision in Boumediene affirming the right of Guantanamo detainees to habeas corpus means nothing if the executive branch can just select another prison and turn the boat, or turn the plane or whatever, right instead of left. So, however, the D.C. Circuit said no access to the courts. So at this point, the Bagram detainees don't have access to any court, be it a U.S. court or an Afghan court. Now, there are a lot of, it's a very complicated question, and there are a lot of issues that have to be gone through to, with the Bagram detentions. But I'll say that the Obama administration has made some changes in terms of the administrative review process that they go through. Something they created, the DRBs, which have improved the process. However, there's significant shortcomings in terms of the use of secret evidence, the use of hearsay, and again, we have a system of indefinite detention, and if and when the U.S. leaves Bagram and leaves Afghanistan, but continues to hold prisoners, I think that the dynamic will look very different, and it's going to look more like Guantanamo than some people think it looks now.
Let me throw a plug in for a former colleague of mine talking about Bagram and referring back to my comment that maybe someday a courageous judge is going to bite the bullet and say that enough is enough at Guantanamo. The Bagram decision initially was written by John Bates, who is a George W. Bush appointee to our court. So any one of you who think that it makes a big difference who appoints a judge to a district court, forget it. Bates is a great judge and gave a very courageous opinion, which was reversed, but it's not the last word yet, is it? Is it going to be?
Well, it's back before him now on remand. Yeah.
Yeah.
Uh, the Supreme Court hasn't had anything to say on these issues since Boumediene, going on 3 years ago. I wonder if each of you would identify what you think is the single most important open legal issue that the Supreme Court ought to decide now.
That's a great question. And let's start with Ambassador Soderberg this time.
I guess for me it would be the detention without trial and the indefinite detention. I think it's underlies a lot of what we're doing here. I was going to also say on the just on the previous question, I think you're going to see an increase in the use of Bagram and other areas. The Obama administration has made it clear they want Iraq and Afghanistan to be able to hold these prisoners over time, so I think you're going to see less and less of them coming here, wherever they go. And as we build up the institutions, particularly in Iraq, I think you'll see them being more and more used under Iraqi and Afghani authorities. But for me, I think the detention without trial is increasingly difficult to defend.
I think it would be, I'll give two answers. One is, what is the proper test for the test for detention? In other words, what is the measure of affiliation with Al-Qaeda that has to be determined? And at the moment, the cases do not give a final answer to that. The second has to do with the military commissions subset. There are cases that are currently pending before the Court of Military Commission Review that will eventually have to get to the D.C. Circuit, and presumably someday the Supreme Court is going to see one of those having to do with, for example, whether conspiracy is or is not a war crime, or material support for terrorism is or is not a war crime. Both of those could directly influence the utility of the military commission as a forum for prosecuting people.
I think actually I would give pretty much the same answers on that. I think the ultimate question of detention is one that I would be surprised, given Hamdi and the current composition of the court, that the court will feel is something to be reopened. I think the definition of who may be detained, which has been hotly contested within the various federal district cases and at the D.C. Circuit, is something that could well give rise to a court case in an appropriate case. And interestingly enough, it might well, if the D.C. Circuit does not grant the writ, which it hasn't, in a number of these cases, Justice Kagan may be recused. And so if one assumes the regular lineup of the court, it may be difficult in some of these cases for the court actually to get a majority to reverse the D.C. Circuit if it comes up in that posture. But I think eventually the commission cases will also generate interesting issues in addition to the definition of the crimes. Also just when we're departing from Article 3 procedures, be it hearsay, be it custodial statements, is it permissible to have different rules in the commission proceedings? And I think in many cases the court may well say yes, but those could be issues that will percolate eventually through the process.
Well, of the three, I agree with everybody. Of the three issues that have been identified, it seems to me that the Supreme Court is least likely to take up the question of exactly what standard applies for detention, because this is something that's working its way out in the lower courts, and it's the kind of thing the court traditionally waits a long time to see how the lower courts deal with it before they pick a case that is cert-worthy. As far as indefinite detention is concerned, same problem, I think. There has to be some combination of outrageous facts and maybe public attention that would make the court take it. My vote of the next issue that will get to the Supreme Court or the Military Commission, what is a war crime question that Gene mentioned.
That's a very important question. It could also be reframed, at least in terms of the habeas litigation, as what action by the D.C. Circuit, particular Judge Randolph, goes so far as to bend Anthony Kennedy's nose out of shape and realize that his work in Boumediene is really being upended. And I think in addition to the issues mentioned, there is the question of the district court's remedial powers, where the courts have granted habeas relief, that is, they found no basis to detain, but under current D.C. Circuit law, there's nothing else a district court can do other than say to the government, use your best efforts to try to repatriate the detainee. And I think that it raises a lot of complicated political problems. There are now legal obstacles in terms of the restrictions about bringing detainees to the United States. And there's also, I think, been understandably some time and space given to the Obama administration on the assumption that they're actually really actively trying to repatriate the detainees. But eventually, if the district courts have no power to enforce their orders and people end up sitting at Guantanamo, Boumediene is really a hollow victory. You can, you win the battle, but you lose the war. And so that may ultimately be a case that goes up.
And I would like to note that the war crimes issue is currently pending in the Courts for Military Review, and it has been there for over a year now. So we haven't heard from that court, which is the first court to hear these issues after a conviction in a military commission system. Once they make the initial determination, then the case will go to the D.C. Circuit Court and then possibly work its way up to the Supreme Court. But given that the first court of review is taking such a long time to get to it, it's really very difficult to know when, if ever, the Supreme Court will take up that issue. He was waiting, and then Gabor, you can go.
I just have one question about the indefinite detention, and that is, who are the 47 detainees that can't be prosecuted or released, or both, frankly? I mean, we talk about it and talk about them kind of generally, but the list isn't public. I mean, shouldn't we have a list of who those detainees are and a public list of who's cleared for transfer so we can talk about specific individuals rather than general concepts which may or may not apply to some of these individuals? Curious about that in terms of
my understanding is they're mostly people who were picked up overseas, and Steve has more information from the report, which I just looked at, which basically some of them were picked up and aren't for informational. They're trying to get information out of them, and they're not linked to a specific crime, but they've now been, I guess, radicalized to the point where they're a threat to the Americans if they were released, but there's not enough information to try them.
I understand that, but I guess it begs the question of who are these individuals?
Yeah, I believe
which
should
ones?
be public. It absolutely should be
what
public.
Are the name,
Well,
who are their names?
One of them is Salahi. Salahi, habeas denied, but he's clearly not triable. They put him through all kinds of, call it torture, call it not torture. His mistreatment was so severe that the government decided they couldn't even try to use it in a habeas case. They have no material support case against him. But he became, by lodging these three people who were later associated with 9/11 in Frankfurt, he became the poster child for the people that we're afraid of. And so they're not going to let him go forever.
I'm curious whether Jonathan agrees with that assessment that he can't be tried or safely released. I mean, Your Honor ordered him released. I understand that was reversed, but I'm
well, not tried or safely released is not the issue. I mean, the issue is...
Well, I understand there are three categories. There are people who are approved for transfer, consistent with the national security interest of the United States. There are people who are designated for prosecution in some form, whatever that might be, whether it's commission or Article 3. And there is the group of 48, who's the balance of, I think, 47 individuals. I'm curious to know sort of how it was decided that, and really who is in that group of 47, and why they aren't either going to be released or prosecuted. I mean,
I think that's what this whole executive order process is supposed to be about, to take another look at those people or to look at them periodically. I mean, Salahi is now tending his garden and drinking tea with his guards. Nobody really thinks Salahi is a dangerous person anymore. He ought to be let out. But he was properly held at the time he was, or he was now held to have been properly held at the time he was picked up, and therefore, by definition, we're going to hang on to him forever, unless this new executive order puts in place a process that will take another look at him, as they sometimes do for people judged guilty by reason of insanity and decide
Same.
whether he's dangerous any longer.
I think they will put in place a regular review, and it won't be just a one-time thing, and it will give the prisoners a chance to request more regular reviews. I'm not sure that's going to result in a whole lot more releases, but I'd love Jonathan's view of this, as we're all hanging
Be
on
like
your
the parole
answer.
board in the Shawshank
I don't-
Redemption.
Yeah, I mean, I think the history of exactly of executive order, it's not, I don't think, very promising. You know, they've already had a task force review, but ultimately, I think I think the question itself is problematic, or the category. I mean, what does it mean someone's too dangerous to release, too difficult to try? I mean, I think I think that if you can't try the person, if you're not able to try the person, then the person, you know, there's not a crime you can convict the person of. The person should not be held. I mean, I think that's a foundational
But no,
principle of our
Jonathan, that's the
society.
easy answer. The tougher question is one that if you can come up with a scenario, you accept that they are a threat. And when you talk to people who've been to Guantanamo and talk to the prisoners, those prisoners, some of them say, the minute I get out of this prison, I'm going to find you, your wife, your children, and kill them all. I know your name, I know where you live, and I'm going to come and get you, Mr. Guard. And I mean, there are threats like that that are real. And so is there any scenario like that that you could expect, that you personally could support as justified in being continually held, although not tried?
I'm not familiar with, I haven't seen those threats, but I think that's probably true with, you know, there are people who we house, you know, in prisons, you know, nearby to where we sit now, who, you know, they think they may commit another crime when they get out. I mean, I don't think you can hold someone if you know, if there's no basis to hold them, if they've served their sentence, certainly for someone who's never been charged and tried, if you know, just because you think they might, you know, do something wrong in the future. I mean, that's a foundational principle, and unfortunately, a legacy of Guantanamo is that's been validated. I think it's been kind of masked by the idea that these are, you know, there's a war and these detainees will return to the battlefield. But, you know, ultimately what we're seeing is a move toward the idea that if you think someone is dangerous, you can hold that person. I don't think that we should have such a category, and I think it's, you know, unconstitutional.
Gene?
This colloquy makes me wonder whether communicating a threat would itself be punishable when done by a person who was in U.S. custody. Certainly it's the case, you know, if you had a prisoner in a state prison or a federal correctional facility or a military prison who's communicating a threat. It's a crime in itself. Now, that's not going to put the person away for the rest of his life, but
Try them on it, you mean?
you
Try
could
them on it,
yeah, and then at least you'd have the closure and you'd have some
There
sort of more normal
Yeah.
system of justice come into play.
There
And
may
that
not
would cut
yeah.
down on threats.
There may not be a law that would cover communicating a threat at Guantanamo. Not that there couldn't be such a law, but
This Congress would certainly pass it.
but this is but it's, I mean, but the practical issue is I mean, these cases definitely do exist. I mean, in terms of individuals who are threatening and sort of attempt to menace specific, you know, American service members. The practical question is the return to the fight one, and it's the question of individuals who are avow or are reliably believed to, upon release, enlist with forces in Afghanistan or Pakistan or Yemen and take up arms against American soldiers who are fighting there now. And if, you know, there is a reliable enough information for which a federal judge in the habeas process will adjudicate that the individual is a member of al-Qaeda, could be held, or a member of the Taliban, or the like, could be held, but not sufficient evidence to convict them, do we release them or do we hold them? And this is where the distinction between the law of war model and the armed conflict model comes into conflict with the civilian Article III criminal law enforcement model. And, you know, I think the law and this administration, like its predecessor, has adopted both models as available, including the law of war model. But, you know, but that's kind of where the rubber meets the road.
Yeah. And I think one final point on your question is, you know, we don't know who they are, and another problem is we don't know what they've been accused of doing. We've just simply been told that they are the worst of the worst and they're difficult to try and we can't release them, but we have absolutely no idea what in particular it is that these individuals have done to get themselves in Guantanamo and not be able to be released. So that's, you know, another issue having with your question.
Actually, Mason, the worst of the worst was Secretary Rumsfeld's description for everybody.
For everyone, that's right.
Guantanamo. So it's not just the
That's
48.
right.
That was everybody. Listen.
Right. Gabor, and then Mr. Gibbons.
Thanks, Mason. This is a great panel. Gene, on military commissions, you mentioned the problems of material support and conspiracy, I guess in the framework of ex post facto or questions of principle of legality, whether they're appropriate as war.
Well, no, it's more, no, it's not just that. It's whether Congress in exercising its power to define and punish offenses against the law of nations permits it to have done that.
Okay, so it's two issues.
It's all right. It's two issues. Yeah.
There's a third substantive crime in the military commissions that has been used that seems to me perhaps even more perniciously.
Murder in the course of.
Yeah, murder by unprivileged belligerent in violation of the laws of war. And in light of the fact that unprivileged belligerency is not a violation of the laws of war.
It's not a war crime.
I wonder if you think that belongs in the package, and especially in light of the fact that there are American civilians who participate in acts of war, and in particular involved in targeted killings, the CIA project.
Gabor, I think that's a terrific question. I'm trying to think of the people who have been convicted by military commission and whose cases and who retain the right to appellate review. The last fellow waived it, I believe. I think Cotter waived it.
Cotter waived it.
Yeah, so the question is there anybody who stands convicted of murder by,
Who can,
I don't know that there is.
Right.
And maybe there will be in the next batch.
The other military commission related issue I just wanted to ask your opinion about is very often what we hear is that, well, okay, to the extent that the military commissions do legitimately cover war crimes, the claim is, well, civilian courts are for civilian crimes and military commissions are for war crimes. I don't hear a lot of discussion about the fact that the U.S. for quite some time has had a War Crimes Act. Which does have extraterritorial jurisdiction.
Yeah.
Do you have any idea why that simply doesn't come up?
No.
Thank you.
Just so I know, what year was that from?
70s or 80s?
I think it was 96, actually.
It
I mean, I think it was the.
It's been amended. It was amended by the military commission.
It was.
Was
Act.
it the Vietnam thing?
No, it was a Clinton administration thing.
Yeah. But we've had a
You
war.
said 76.
I think it was 96.
96.
It covers certain offenses, and so I mean certainly would be an avenue in which, if the administration or the Department of Justice wanted to pursue these crimes, it could pursue crimes under the War Crimes Act. It's a more limited category of crimes, and so, for example, to the extent we're talking about material support or conspiracy or the like that have been used in the commission system and or may not have the jurisdictional predicate in terms of their civilian counterparts, it may not always be useful, in these cases. But certainly some of the acts, that have been committed and things like the 9/11 case, one would think that, that the War Crimes Act could apply.
But your question, it's a wonderful question and makes me think that there are either treasures or the opposite of treasures lurking in the U.S. Code that we don't use. Another one that comes to mind is the Patriot Act provision for detention. It's never, as I understand, it's never been used. Correct me if I'm wrong. Yeah, well, yes, but it's something, and B, I gather that progress in interrogations usually happens in the short term rather than, months down the road or much less years down the road. Also, your intelligence, regardless of when people start to talk, when they start to talk may determine whether their information is worth anything.
Mr. Gibbons? Well, okay, you're going to make your way to the microphone.
I have a question for Mr. Engel. You started your remarks by saying we're at war. Now, war is a word of indefinite meaning unless it's defined. But it is defined. It's defined in the 4 Geneva Conventions, and they are enforced by federal statutes. It defines soldiers. The people in Guantanamo are not being treated as soldiers. Everybody concedes that. For everybody else, Article 3 applies. And these people are not being treated as Article 3 requires. Now, some time back in the history of the country, you could say, well, we're at war and therefore we can detain people indefinitely. And the Supreme Court, in the most disgraceful case it ever decided, said, yeah, you can treat the Japanese that way, Japanese American citizens that way. Are we talking about by calling something war, we can just disregard the fact that Congress said mea culpa about the way we treated the Japanese? The second...
Can I comment on that?
Sure.
Without prejudice to your additional arguments, counsel? I do. It's a much broader. It opens a very broad vista. And just to be philosophical for a second, I personally think we have drifted too far from the shore in terms of the exercise of the war power. I think we have gotten ourselves into the habit of doing war on the cheap, not in terms of the expense. That's obviously, that's the exact opposite. We do fabulously expensive wars. But in terms of the political process, the framers had something in mind by requiring a congressional declaration or contemplating a congressional declaration. I think it's very unfortunate that we've gotten away from that. Just as I think it's unfortunate that we've gotten away from the classical model of the exercise of the treaty power with this, jungle of executive agreements. So I think I believe that I should have a lot of allies in the Tea Party movement and originalists on the Supreme Court and elsewhere for this view. But as a practical matter, it's a very small minority of people that are concerned about this.
Yeah, but as lawyers, we have to be in the minority.
So I'm happy.
That seems to be the case.
I'm happy to provide a lawyer's answer to the question, which I think is a fair question. There's two frameworks. There are two legal rubrics at work when we're talking about the issues that you raise. One of which is domestic law, and one of which is international law. With respect to domestic law, the United States government, through both administrations, and certainly since Hamdan, has taken the view that the authorization for the use of military force in Hamdi is the source of the domestic authority for the president's war powers in Afghanistan and against al-Qaeda and the like. And that's what's been relied upon. The Bush administration is what's been relied upon by the Obama administration. With respect to your question about the Geneva Conventions and the international law of war, I agree with you that Common Article 3 has been held by the Supreme Court anyway to be the governing international legal framework for defining war and defining the treatment of individuals detained in the context of the law of war. I would take the view that folks are being treated consistent with Common Article 3. The United States government, the administration, takes that view as well.
Well, Common Article 3 prohibits torture, and there has been torture.
That's a point of view.
That's a point of view that at least the courts in the Southern District of New York accepted, and there is a pending case there attempting to hold certain high government officials in civil contempt for destroying the evidence of the torture.
There's no question, I think, you get universal agreement that torture is not permitted under domestic or international law, and then certainly folks have debated, the torture question with respect to other individuals. So, I mean,
well,
nobody will debate the principle.
I'm sure there are other people who want to be heard.
Thank you, Mr. Gibbons. I think we have time for one more question. Yes, sir?
Yeah, just a broad question. As the constitutional project, and I guess anyone in the panel could address this, are there any historically based studies on societal effects of suspension of habeas and expanded Military Powers Act on general societal effects, historically based studies?
That's not something that we have analyzed directly, but we do address some of those issues in the habeas works reports, which you're welcome to have a copy of. But I think our other panelists could address that more specifically. Jonathan?
I mean, I'm not sure. I mean, I would say that I think actually a lot of the effects of what we're talking about here, we talked about today, aren't felt. And I think that they seem very distant from people generally, which is, partly explains, why there's not the same, political outcry, or what Jean Fidel referred to as the fatigue. But I think that there's actually not a sense of that the infringements of civil liberties in terms of, indefinite detention or prior mistreatment of detainees is not felt by a lot of people and is defined as other, or something that doesn't happen to, U.S. citizens, with the notable exception of someone like Jose Padilla. And I think that explains it. Actually, if you look at where you have other, policies related to counterterrorism, for example, body scanners, where, many Americans are, exposed to them, you see a sharp, outcry and a sharp opposition, I think. But I think a lot of these policies is their effect is actually not felt and not experienced by people.
It's an important question, and it's a great question for us to end. And it's not really an ending, it's the beginning of an important conversation. These matters, I don't think, lend themselves to research as such. I'm not a numbers guy. I'm not that's okay, but I'm not a numbers guy, and however, let me just offer this observation. There's this phrase, my Latin's very poor, but it's inter armes silent leges. Who can do a good translation of that? When the guns are firing, the laws fall silent, or something like that, words to that effect. And I believe that Lincoln may have used it. Rehnquist used it when writing about the U.S. Civil liberties history during the course of the Civil War. And there was implicit in that as the sense that, kind of all bets are off, or a lot of bets are off when the country is under stress, and an implication that the lifeboat will, return to its normal horizontal position, and the keel will be even in due course. And so we had that same feeling after World War II. Maybe it took us longer than it should have to apologize, for example. But I think what people in the civil liberties community have been concerned about is that it's not inevitable that the lifeboat will achieve its former balance, and that it is not inevitable that the pendulum will swing back to where it was before. Not, assuming you liked where it was before. There's a premise built in there. That's the best I can do, and that concern is what led me to talk at the beginning about about the fact that irredentism, an unwillingness to make peace with that proposition, has something to recommend it.
And I lied. I have one question for the judge. You said that the simple answer to whether there's anything that judges can do about indefinite detention is no, but I'm interested to know if you think that judges will consider a system of periodic review if it is in fact provided in this future executive order in making their decisions in these habeas cases.
Oh, yeah. As a matter of fact, as a footnote to that whole executive order thing, the issue running through my mind when Jean was talking about it, and Jean is the administrative lawyer par excellence, is whether the enactment or the issuance of an executive order, with or without notice and comment, would give rise to an APA claim based on the executive order that we might not otherwise have. It'd be kind of interesting to see whether there is another right of action for review of administrative action under such an executive order, and that might provide a jurisdictional prong for doing what I don't think a judge can do today. Will judges consider it? You mean maybe your question is, will judges say, oh, don't worry about it, it's going to be taken care of by the periodic review? I think most judges are pretty outraged by the amount of time that people are being held without trial, and as soon as they see any kind of an opening, whether or not there is an executive order, they'll take it. One of my late and great colleagues on our district court was named Bill Bryant, who had a gift for metaphor, and he said, well, judges can't go out and look for targets. He said, judges are kind of like that cannon sitting at the mouth of the harbor. And you can't change the range and you can't change the bearing, but every once in a while something comes within range. And if it comes within range, boom. And one of these days something is going to come within range of a district judge.
Well, thank you. Please join me in thanking our panelists. And thank you for joining us. Have a great day.
It's a great metaphor. Yeah, I think that's right.
Very nice to meet you.
A pleasure.
Appreciate it.
A pleasure.
Definitely getting much in Washington. There might be something I can do.
Yeah.
We use a lot of the